coincidentally or otherwise, in December 1980, the government stopped funding the projects. Can I say definitely the decision to stop funding these projects was a deliberate payback for public criticism? No, I can't. But that is my perception, and perceptions play a key role in what we're discussing here this evening. Attempts, as I said, to stifle the voices of those who advocate on behalf of the voiceless are not new, and neither are they unique to Ireland. Sometimes overtly, and sometimes in very subtle and refined ways, pressure is brought to bear on those whose work entails speaking out against government policy. Why should that matter? There are people who would say that people, particularly those in receipt of state funding, should just get on with the job and not be politicking. There are just 2 points I would want to make with regard to that. One is that tolerance of dissent is, I believe, crucial in a modern democracy. And organisations whose remit is to work with disadvantaged and marginalised people and to speak with them and on their behalf are charged with changing the society and to make it a fairer place to live in and to remove the obstacles to achieving a just society. And at times this will inevitably mean considered criticisms of the status quo. And failure to criticise, I believe, is a failing the people on the margins who otherwise wouldn't have a voice. Secondly, where intolerance of criticism extends to an unwillingness to listen to suggestions about a better way forward or suggestions of another way of doing government business or providing services, can have very real and severe consequences. The result can be the promotion of mediocrity, the perception that existing ways are fine the way they are. At the other end of the spectrum, the scandalous can be allowed to occur without scandal. And in some cases it results in a denial of justice. And I'd just like to outline for you now one example of that kind of injustice that I've come across in my work with the Immigrant Council of Ireland. Many of you will know that there is no independent appeals tribunal in Ireland for immigration-related decisions. Seeking a judicial review in the High Court is the only way to challenge an unjust decision in many types of immigration-related decisions. This is expensive, it is time-consuming, it is stressful for people involved, and it clogs up the courts. The government has in the past laid the blame for clogging the courts at the feet of what it describes as litigation-hungry lawyers. However, that is not our experience in the Immigrant Council. Our experience is that almost all the cases taken are settled after an offer by the government, which in fact means the government is acknowledging that it cannot stand over the decision it made. In many cases, settlements offered are being made on condition that the terms of the settlement remains confidential. And that's fair enough in some instances. But what's very disturbing is that we are aware that the practice of imposing confidentiality has taken a step further in recent times. We're aware the government is at times offering settlements in relation to some cases taken against it on condition that even the fact that the proceedings occurred are to remain confidential. In other words, organisations are being told that the government will settle on condition that there is no public statement that a case was ever brought about this particular issue. This, I believe, is a fundamental attack on democracy and justice. It is an attempt to expunge dissent from the public record. So what does the government stand to gain from this if it becomes the norm? To use the immigration policy as an example, the potential impact of this approach can be far-reaching. Firstly, there is no publicity about the case, so migrants experiencing similar circumstances to those challenged could remain totally aware that a case was taken and that was settled. For some, this will mean remaining unaware of their rights or the opportunity to rectify the injustice. Secondly, the fact that this expensive court process has occurred as a result of the sorry state of our immigration legislation and policies does not receive public scrutiny, nor does the amount of money and resources wasted. The debate for the need for a fairer, clearer and more transparent immigration laws and a more efficient administration does not occur. However, the fact that judicial reviews have been sought in the High Court and the fact that they have been settled cannot be completely wiped out from public consciousness. Our courts remain open, and I would strongly appeal to the media to be vigilant in this regard. Today, I believe in Irish society there is a worryingly wide range of methods used to stifle the voices of those who advocate on behalf of the marginalised. There is the introduction of legislation such as the Charities Act, which won't allow new organisations which state one of their aims is to advocate with regard to human rights to be registered as a charity. That is worrying. Cutting funding to organisations who cause embarrassment or who challenge the status quo. That is worrying. Including clauses in funding contracts or employment contracts which prevent organisations or individuals from speaking out. That is worrying. Using anonymous official sources to discredit the work of NGOs in the media. That is worrying. Making state-funded organisations seek clearance of press releases or publications from government department before they are released. That is worrying. And creating and fostering an environment where there is a prevailing perception that dissenting views are unwelcome or at worst disadvantageous for the NGO's client base. That is worrying. These are not signs of freely accepting a Muslim, but of the very difficult and stark choices that sometimes have to be made. Since 1980, we witnessed significant changes in how the state engages with the community and voluntary sector, as well as legislative changes regarding the promotion of human rights and access to information. The community and voluntary sector is now, as we've heard already, now an effective partner within the social partnership framework, but as Kumi and Jack has asked, does access mean influence? To what degree do they enjoy influence? And to what degree are their voices silenced as a result of being involved? I believe that the marginalisation of dissent is most apparent in the weakness of the voices expressing dissent. And I believe there is a direct link between this weakness and the pressure brought to bear on voluntary bodies who must negotiate with the state over planning and funding of their services. Key factors to enabling dissent are good governance and open government, proper resourcing and enabling a broad remit for equality infrastructure, the Human Rights Commission, the Equality Authority, the Ombudsman's Office, and ending the restrictions in the Freedom of Information Act would be good indicators of a commitment to openness. Unfortunately, we don't have these indicators today. Openness and accountability by the state, the churches, the community and voluntary sector is key to promoting a resilient society and enabling dissent. And a questioning media has a central role to play. I believe that voicing dissent to uphold the rights of the marginalised is not turning on the hand that feeds us. It is crucial to an open, democratic society. Thank you.